Hello, everyone. I'm very happy to have this opportunity to attend KIMPA Congress this year. My name is Xiaolin Dang. I'm a patent attorney and also attorney at law. I practice primarily in the patent field, including prosecution and also litigation, over 20 years. This time, I would like to share some information about the recent development on examination on AI-related inventions in China. Yeah, now I would like to start the topic this time. In this time, I would like to report in two aspects. First part is the latest rules of examination on AI-related inventions. The second part, I would like to explain a case and also analysis of the case. So these are the main rules relating to patentability of AI-related inventions, including eligibility, enablement requirement, and also novelty and inventiveness. So I would like to start from the first one. For the eligibility, especially for the AI-related matters, there are several eligible subject matters based on the guideline and also the practice. So usually, AI-related invention is substantially a method. So method claim is acceptable. And then with the drafting skill, we can convert a method into a virtual product, such as draft a step feature into a unit or model for that feature. And with that, mix the measure of the claim, such as the software plus hardware, is allowed in China. In the past, the claim should be a purely software format or a hardware format. So the mixed one with the part of the software and also part of the hardware were not allowed several years ago. But in recent years, it was accepted by the patent office in China. So that will give more room for the patent attorney in drafting. And the storage medium is also acceptable. In this point, I would like to point out that program proceed is still not patentable. But anyway, if we want to protect a program, a software itself, then we can convert it into a storage medium format, such as computer readable storage medium that stores a computer program for doing something. And then the computer program can enable a computer to execute steps of the following, which could be the same as a method claim. So we should be aware that for the format matter of the claim, that we should not draft the claim as a program, but change it to storage medium. In addition, data structure is not applicable and not protectable. Yeah, for the eligibility, there are several conventional rules. The basic rule is in the patent law, such as in Article 2, that it defines what is claimed as a patent or as an invention. So it should be a technical solution. But anyway, what is a technical solution is still abstract. And in Article 25, there are also an excluding area, that is, rules and the method of mental activities are not patentable. So we come back to the technical solution matter. In the examination guideline, there's a relatively specific explanation. We use three technical elements test, such as for determining whether claim is a technical solution, there shall be a technical problem to be solved. And then in the claim, there shall record technical features. And then the technical solution should obtain a technical effect. So that is very typical. I will skip the details. So in practice, there are two ways to show or to prove that is a patentable subject matter. In one aspect, that if the claim is an improvement of internal objects, such as internal performance of the computer system. For example, a method for expanding storage capacity of a mobile computing equipment could be considered as an eligible subject matter because it's related to the improvement of an internal object. But a method of computer game is considered as non-patentable. In the practice, most of the applicable subject matter with eligibility will fall in the second category or second way. That is the improvement of the external object, such as to control of industry process or measure or test the process. For example, a method for measuring liquid viscosity by computer program, or a method to remove image noise. Those are the use of the software in combination with an external matter, such as the image process or the liquid. Now we come to the main point for the eligibility. It's the recent change. There was an amendment in the examination guideline, which was effective from February 1st of this year. There's a new added complete unit named as Relevant Regulation on Examination of Invention Patent Applications that contain algorithmic features or business rules and method features. So here, although the topic today is the eligibility of AI-related matters, but anyway, in the recent amendment of the guideline, it covers not only the invention for AI, but also Internet Plus, big data, and blockchain, those areas. I would like to explain the background of this amendment. This area, this specific technical field, was the field that the government want to encourage, because the development of this technology in China is very fast, and especially the utilization of those technology in encouraging the development of economic is very fast now. And I think the government want to encourage the industry to pay more attention in that area and then to benefit from the development, such as get protection by patent. So in the amendment, based on my understanding, I summarized several rules. I find that there may be 3 points. First is that as a general idea or general rule that what is patentable for the AI-related matters, if the application, including the algorithm features or business mode features that solve technical problem, use technical means, or obtain technical effect, that is a 3 technical element test, then it's patentable. So the basic rule is still the same, but for details, there are another 2 very important points that a scenario of application should be described in the specification and the claims. Also, if there is an interaction between the technical feature and the non-technical feature, such as the algorithm or business mode features, then such feature should be considered as a whole during the inventiveness examination, which is very important. I will explain later for details. Here, this figure shows the kind of a relationship among those aspects. We're starting from the first left part, that if there's a application scenario in the invention, that means the invention is used in a very specific technical field. There should be some technical element. And also with the algorithm or business mode matters, which are considered as non-technical matters, if there is an interrelationship or relevancy between those 2 parts, and the 2 parts will be considered as a whole, as 1 unit. And with that, we can also show that because there is a technical matter with those algorithm matters, we can show the usually external object, such as if the application scenario is image, then we can show the image analysis, or such as a search engine, or intelligent translation, or facial recognition. So with those aspects, we can show that the claim is in the either of 2 categories, internal object or external object. Here are some advice for patent drafting, especially for the disclosure or enablement requirement. if a scenario of application is described, especially with the interaction with those technical features and algorithm or business mode features, in that rule, so in the specification, there should be some details for the scenario for application or and the interaction between the technical feature and the non-technical feature, such as how the technical features and the non-technical feature are functionally interrelated and how do they interact with each other and co-acting to generate some benefit effect. And also the specification should describe a technical effect. That means the beneficial effect from that solution, especially from the interaction between the technical feature and the non-technical feature, such as the increase on quality or accuracy or efficiency, improvement on system internal performance. Here, I would like to point out that the enhancement on user experience is considered as a technical effect. In the past, usually if the benefit aspect is only to improve the user experience, the examiner may not consider that as a technical feature. But in recent, especially with the recent change of the guideline, now I detect that the examiner, they accepted the user experience as technical effect. So that is quite favorable to the applicant side. For example, online shopping now is very popular. And the traditional online shopping that there's a shop online displaying a lot of items with pictures or videos or some descriptions. The difference between shopping online and the shopping in a physical shop is that you cannot touch the product. So how about a cloth? For example, a shirt. You can see the shirt for details, but anyway, you cannot try it on. So we understand that maybe you know the size, but anyway, whether it fit you, you do not know. And whether that clothes fit you for the outlooking, make you look more handsome or beautiful, is unknown. So here is an invention. They made the combination of the virtual experience or the virtual try-on experience that there's a camera, so take your image, and then if you click or choose a cloth, then the software will make a combination, put the clothes on your image. It seems like you are trying that clothes, so you will see what is the result when you try it on. And if you move, turn around, the combined image will also follow your move. So that will give you a better experience for the online shopping. In that aspect, the improvement of user experience is considered as a technical effect. So that is important. And for the novelty and the inventiveness issue, as I explained, that based on my understanding from the new amendment, the technical feature and the non-technical feature should have a interrelationship. If we meet that requirement, then the technical feature should be considered in whole with the algorithm or business features. In that situation, it will make the argument for inventiveness easier than separate. And in that situation, it's different from the previous situation that the examiner usually will not separate the algorithm or business mode matters isolated matter. Usually that will be considered as only the man-made rule and give less weight for that. But if you take the technical feature and the non-technical feature as a whole, so the examiner will give more weight on that. So there will be more chance to argue for inventiveness. Yeah, here I would like to show case. In the screen, there's some information about the case, but anyway, is generated from a real case, but I made some change. In the first of section, the examiner object claims 3 independent claims on the eligibility issue. So there is a method claim and also a program claim and a device claim. So for method claim is considered as a non-patentable subject matter under Article 2. And also for others with a similar reason, the examiner issued the objection. So how to deal with that? Now we examine the details of method claim. So it's a method for generating two-class classification prediction mode, comprising so many steps like obtaining something and calculating something or determining something. And those are a very typical method claim for a software. And in responding to the objection, the applicant made an amendment. The amendment is that to change the subject matter with specific scenario of application. That is to replace two-class classification, which is very abstract, into a specific technical field, such as a method for generating compound toxic prediction model. So with that change, we argued, since the specific technical field has been added with a scenario of application, and we use the three technical element tests to argue it is eligible subject matter. But anyway, the examiner issued a second objection, insists on his previous objection. In this stage, actually, we made a phone call with the examiner to discuss with him. We explain our grounds orally and to attract the examiner attention on the new amendment. And finally, the examiner agreed. For this matter, I also want to point out that currently the patent office is under the great suffer to improve the quality of the examination and also to speed up the examination speed. So to deal with that, telephone discussion is very useful to solve the problem that the examiner may have less time to examine the case, or the examiner may give less chance to the applicant to have a further objection. So to avoid a direct rejection, telephone discussion is very, very useful, especially for this case. We can explain our argument clearly and orally with the examiner. And with that, we made an argument purely in the written response after the telephone discussion. So our written argument is that the compound is a natural material, and the compound toxic is an inherent natural characteristic which depends on the structure of the compound, but not determined by the human being, not a man-made rule. So that is follows the natural law and limited by the natural law. So with the written argument, the examiner finally agreed the eligibility matter. This is actually a new case, a new example, but I made a change that make it as a variation based on case 1. So we name it as a case 1 plus. It's a hypothetical case based on another real case. Also, the similar claims, but the problem is that it was filed by claiming a priority of a previous Japanese application. But in the Japanese priority application, there is no specific scenario in claims and also in descriptions. But the result in Japan is that it was granted. But anyway, in the Chinese filing, we cannot add the specific scenario because it will be a new matter and will not be accepted. But without the specific scenario, it cannot meet the rule of eligibility. So finally, it's a dead case. This case also have a quite tricky timing that the priority was filed before the effective of the Chinese amendment. And the Chinese filing was just a little bit before the Chinese amendment. So later on, the patent office used a new amendment to examine the pending cases. So it's a pity for that case. Those are the information I would like to share. Thank you so much.